ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, respected teachers and managers, honorable doctors and directors, honorable advocates, graduate administrative advisors, the most honorable President Prime Minister Modi ji, my Dr. Rakesh from USA, heartily cordially welcome. Dear friends, as you know that our India is known by its cultural varieties, adversities, and full of shape, size, color of the objects, things, persons, places. We observe through the newspapers, Hindi newspapers, from print media, electronic media, and digital media. Day by day, what changes we observe in nature, climatically, as well culturally. Our India basically is known by the land of festivals. We celebrate different festivals according to nature. All are nature based. Nature determine all festivals, and every festival contain the message of oneness, equality, unity, humanity. That makes our country better, nicer, finer. Undoubtedly, our great men, saints, philosophers, freedom fighters, free thinkers, those who came in India for addressing the message of love and brotherhood, peace of mind, tranquility of heart. They spent their whole life in giving us the message of new love, science to spirituality, language to meditation. In spite of this, in our society, we don't have same kind of people with same ideas, with same thoughts. Because of the different actions, we are to study, we are to read, write, speak, listen. Out of them, can a single act be both a crime and an offense? Law of torts, Consumer Protection and Motor Vehicle Act. Crime has evolved from thoughts, or if we say that thought is a small unit of a big crime, or thought is the beginning of crime, then probably it will not be an exaggeration. That is, both are similar to each other. So the same act can come under the category of crime and told in some condition. Although the nature, form, method, process of crime and tort are different. But still an act can be of such a type that it can be all three: tort, crime and contract. In fact, until the society does not consider any act to be very harmful, it keeps it in the category of tort. When the social system accepts that any act is very harmful and cannot be left to the person alone, then the state makes a law and gives that act the status of crime. Then it comes under the categories of both crime and tort. Therefore, we can say that any act can come under the category of both crime and tort. The following acts can be said to be included in both crime and tort, such as assault, false imprisonment, defamation, malicious prosecution, obstruction, negligence, etc. Let us define parental and quasi-parental rights. Just as no suit can be filed against parents or guardians, similarly, under this right, no suit can be filed against parents or guardians, gurus, teachers, lecturers, coaches or wardens, etc. also have this right. The rights given to these persons are called parental and quasi-parental rights. Just as parents work for the improvement and development of their children, similarly, teachers, coaches or wardens are covered under this exception for the use of reasonable force, for the education, improvement and development of their children, or for any harm or damage caused in doing so. Because they too, like parents, can ensure the welfare of the dependent in the best possible way, these persons can get compensation only if they have done the work in good faith, reasonably and politely. This right ends when the child attains adulthood. In an interesting case, a school had a rule that students would not smoke inside or outside the school. A student was smoking on his way home. The teacher brought the student to school and punished him. It was held that the student's parents had given the teacher the authority to punish him as needed, and the punishment given was fair and necessary. In this way, if a teacher uses force in teaching or training a student, no case can be filed against him. These rights are called parental and quasi-parental rights. That's defined ubi jus ibi remedium. The principle, where there is a right, there is remedy, can be given another name such as ubiquitous. It is also called just ibi remedium, which means in English, there is a right, there is a remedy, which in Hindi is called the formula. Where there is a right, there is a remedy. This is an important principle of tort law. The idea of any right without a remedy is futile. In Bradley v. Gossett, Justice Stephen held that where there is no legal remedy, there is no legal wrong. What are fundamental rights? These are the fundamental rights given by the Constitution of India, and if these fundamental rights are violated, if this happens, any person can file a petition in the Supreme Court and High Court under Article 32 and 226. That is, while the Constitution of India has given fundamental rights, it has also provided remedies in case of their violation. What are legal rights? Legal rights are the rights which are given to a person by birth and by law, such as right of way, right to walk on the road, right to own property, right to vote, etc. If these legal rights are violated, any person can file a claim under tort law and obtain compensation. Ashby versus White, 1700C. This is a directive case on damage without harm. In this case, the defendant was an election officer who mistakenly did not accept the plaintiff's ballot paper in the British Parliament election of 1701. The plaintiff had proved that he was entitled to vote and he was improperly not allowed to exercise his franchise. The candidate for whom he wanted to vote was declared victorious with a comfortable majority. It was argued that the candidate for whom the voter or plaintiff wanted to vote had already won with a comfortable majority So the plaintiff's claim was not maintainable. Therefore, no real or economic loss had been suffered by him. Chief Justice Holt, while rejecting the defense, said, loss is inherent in every damage. Even if it does not have a clear effect on the plaintiff, loss is not only economic, violation of a person's rights, or interference in those rights by someone is a loss. Let us explain felonious torts according to ancient opinion. The principle of merger of tort into crime has been accepted in ancient cases. It was decided that there could not be double action for the same act in both civil and criminal cases. It can be said that such criminal remedies used by destroy civil remedies. There were decisions regarding this principle according to which there could be no actual merging of tort into crime. When the facts of a case were serious crimes, if possession was shown under tort, then there was no civil remedy for such wrongful act until the culprit was punished. Under Indian law, there was never a rule that the offender should be prosecuted and punished in a criminal court before filing a claim in a civil court. In fact, Indian courts are of the opinion that even if the criminal case against a defendant fails, the plaintiff still has the right to sue him in a civil court. In India, it is not mandatory to take criminal court action before filing a civil suit for damages for a criminal tort. Civil proceedings should be kept in abeyance till the decisions of the criminal court. Let us explain doctrine of last opportunity rule. In the case of Davis versus Mann, 1842, the plaintiff tied both the legs of his donkey and left it on the public road. The defendant's horse cart was going fast, due to which the donkey got crushed. The plaintiff filed a case of negligence against the defendant. It was decided that the defendant was responsible, although the donkey was there inappropriately. But the defendant had the duty to go on the road at such a speed that the accident could be avoided. The defendant was held liable for negligence because the defendant had sufficient opportunity that he could avoid the adverse consequences of the danger caused by the plaintiff's contributory negligence by using reasonable vigilance, and Question Justice Park B observed in his decision that although the donkey was on the road in a faulty manner, but the defendant should have gone on the road at such a speed that the accident could be avoided. If this is not so, then any person will justify his act by running his car over the goods lying on someone's public road or over a person sleeping there, or by intentionally colliding with a car going on the wrong side. When an event occurs as a result of the joint negligence of two persons, the one who causes the incident to take place is liable. He gets the last chance to prevent the accident. He is also liable for the other's losses. This principle was presented in Radley versus London Railway, and it was said that if the defendant had the last chance to prevent the accident despite negligence, then the defendant cannot escape his responsibility. In Radley versus London Railway Company 1876, servants from the plaintiff's coal mine negligently loaded coal in a truck to a great height. The plaintiff had a breach near his mine. The defendant called trucks used to pass through this breach. The truck loaded with coal got stuck in the breach. The defendant did not pay attention to the reason why the trucks had stopped and started the engine rapidly and pushed the truck from behind to cross the bridge. As a result, the plaintiff's bridge broke and fell. The court decided that the defendant was liable for negligence because although the plaintiff had neglected to load too much goods on the truck, yet the last chance to avoid the accident was available to the defendants, and if they had taken ordinary care, the accident could have been avoided. In the case of Union of India versus Hanuman Prasad, year 1989, the Calcutta High Court has observed that the test to determine the question of contributory negligence is who had the last chance to avoid the accident. In this case, the driver of the chain engine applied vacuum as soon as he saw the truck. Despite this, the body of the truck got hit by the train engine. The driver of the train was not in a position to control over than this. But if the driver of the truck had been alert, he could have avoided the accident by stopping the truck near the level crossing. The driver of the truck had the last chance to avoid the accident. Although some initial negligence was committed by the railway, still the argument of contributory negligence could be taken. Let us define mayhem. This is an injury in which a person is deprived of any functional part of his body or sense organs. This does not result in death of any person, but other torts like a death, This is considered to be the most serious injury as compared to flogging, etc. If a person is deprived of his hands, feet, fingers, toes, teeth, penis, nose and ears, then this act will be considered as the tort of mutilation. If a person's functional body part is not broken, then this act will be an assault and not a mutilation. Cutting off nose or ear will definitely make a person ugly, but this act will not be called a mutilation of a functional body part, and a case of mutilation cannot be filed for it. The vital organs of a person with which he carries out his daily activities are considered functional organs. The vital organs of a person with which he carries out his daily activities are considered functional organs. The basis of the test is that the functional organ of a person should be cut off. Cutting off a person's penis is a good example of mutilation. It is a good example of mutilation. The torts of assault, beating and mutilation are automatically actionable in this. The torts of assault, beating, mutilation are automatically actionable per se. In this, the loss of any specific damage does not have to be proved. Rather, the court itself estimates the damage along with being a tort. Assault, beating and mutilation also come under the category of crime. Therefore, if a criminal case is being tried in the court, then there is no restriction on filing a separate civil case. Let us define innuendo. Sometimes statements do not appear to be defamatory, prima facie, on the surface, because the statements appear innocent, but on looking at their underlying context, they appear to be defamatory. When the natural and ordinary meaning of a statement appears innocent, but its secondary meaning due to its context makes it defamatory, then such statements are called vacuity. Generally, words and sentences should be interpreted in their neutral meaning, natural meaning. But some invisible, hidden or concealed element in them changes the sense of the sentence, and their literal meaning is not what is revealed, but according to its context. Only the manner of use of words makes the entire statement defamatory, which otherwise appears very ordinary. If the plaintiff takes a defamation action against such words, then the plaintiff can take a defamation action against them. Then he has to prove that secondary meaning and such irony will also be considered defamatory. Sometimes words spoken in praise also come under the category of defamation due to irony. For example, saying that A is an honest person and he cannot steal my watch is indirectly accusing A of Strilinga words which can be defamatory. Similarly, sometimes using words like saint and sadhu etc. also becomes defamatory, otherwise these words are shaggy. Let us explain. Res ifsha. Res ifsha locutor. Res ifsha locutor is a rule which is called pratyaksham. Pratyaksham kim Ramanam in Sanskrit language, which means incident itself is proof. That is, incident itself tells its story. When we file a case against the person responsible for an incident, he has to prove the fault of the defendant and prove that this act or mistake has actually happened and the defendant is definitely responsible for it. But there are many incidents in which the plaintiff does not need to prove this because direct evidence does not require a result. Subhagwanti versus Municipal Corporation of Delhi, year 1966, SC 1759. In this case, the plaintiff's husband and other persons traveling in a car died due to the sudden collapse of the clock tower situated in Chandni Chowk, Delhi. Evidence was given in the court that the clock tower was 80 years old and the life of such tall buildings was generally 40 to 45 years. The responsibility of its maintenance was on the applicant. All these facts were in the notice of the appellant, yet the repair work was not done. The Supreme Court held that the appellant corporation was itself responsible under the circumstances. Shyam Sundar versus State of Rajasthan, AIR 1974, SC 890. In this case, the plaintiff was a storekeeper in the state government. A truck of a public department for famine relief caught fire. Passengers were asked to jump off the plaintiff. While jumping, hit a rock and later died. The suit was filed by the window. The Supreme Court held that a road where the vehicle does not normally catch fire, but the truck's engine radiator would overheat frequently. The driver had to put water in it every 6 to 7 miles and could not cover a distance of 70 miles on the first day. It took 9 hours to do this. This makes it clear that the incident requires proof. State of Haryana versus Santa Devi, AIR 2000. It was held that the birth of a child after sterilization operation was a result of negligence and the state was held liable for damages under the principle of res ipsa loquitur. Res ipsa loquitur. Collector of Ganjam versus Collector of Ganjam versus Chandgama Das, AIR 1972, In this case, the plaintiff went to the government hospital for his treatment. When he was standing under the veranda with his bicycle, the roof collapsed and he died. The hospital building was constructed 3 years ago. In this, the defense of act of God was not considered. The circumstances speak for themselves. The defendants were held liable for negligence. Let us explain the power to make rules of the government in the Motor Vehicles Act 1988. The state government may make rules for the purpose of carrying out the provisions of section 165 to 174 of the Motor Vehicles Act 1988, and in particular such rules may be made as follows. The form of application for claim for compensation and the particulars it may contain, and the fees, if any, to be paid in respect of such application. The procedure to be followed by the claims tribunal in holding an injury under this chapter. Powers vested in a civil court, while powers vested in the civil court which the claims tribunal may exercise. The form and manner in which and the fees on payment of which an appeal may be preferred against the award of the claims tribunal. Any other matter which is to be or may be prescribed. What do you mean by inevitable accident? According to Sir Frederick Polo, an inevitable accident is an event which a person of ordinary intelligence cannot prevent despite taking the necessary precautions or vigilance in the circumstances in which it occurs. These are such acts which a person cannot prevent even with ordinary intelligence or necessary caution in the circumstances in which it happened. These events are not the result of natural changes, that is, they do not depend on natural forces. The important thing about this is that the defendant will get this defense only when he himself proves that he had taken reasonable care in those circumstances, but the accident still happened. On this subject, the case of Padmavati versus Duganyaika, 1957, one Karnataka LJ, 1993, is important. In this case, two strangers got into a jeep. After traveling some distance, the bolt of the front right wheel of the jeep became loose, due to which the wheel came off the axle and the jeep overturned, and both the persons were seriously injured, one of whom died later. It was held that it was an unavoidable accident, as there was no evidence that there was any superficial defect which would have been apparent if periodic checkup had been carried out. Therefore, the court acquitted the defendant driver and his employer and dismissed the plaintiff's claim for compensation. Another similar case in Brown versus Kendall 1859, 6 Cushing 292. In this case, the dogs of the plaintiff and the defendant were fighting with each other. The defendant was beating the dogs. To separate them, and the plaintiff was standing there watching this incident. In this sequence, the plaintiff got injured in the eye by the defendant. The plaintiff sued the defendant for damage. The court decided that the act of the defendant was an inevitable event in which carelessness and negligence were involved. Vigilance is not a concern. Separating the fighting dogs was a reasonable action, and if in the process the plaintiff's eye got injured, then the plaintiff has no right to get damage. Let us explain the pigeon hole theory. An important question related to the law of torts arises whether it is the law of tort or the law of tort. Whether it is the law of tort or the law of torts. Two theories have been propounded in this regard. According to the first theory, it is the law of tort whose supporters are Sir Frederick Pollock and Dr. Winfield. According to this theory, all harmful acts which do not have any justifiable reason come under tort. If a person causes harm or damage to his neighbor, then the neighbor can file a tort case against him. Whether that improper act comes under special types of acts like attack, assault, fraud or cheating or insulting promise, or it does not have any special name. But law does not include only those wrongful acts which have special names, but it includes all those harmful acts which are considered improper. According to the second theory, whose supporters are John Salmon, Dr. Stalybrush and Dr. Jenks, just as the penal law is a set of rules that establish specific crimes. Similarly, the tort law is also a set of certain rules that establish specific harmful acts. Therefore, according to this theory, only certain improper acts fall in the category of torts. Dr. Winfield had addressed this principle as the principle of pigeon house. According to this, the plaintiff will have to place his case in a pigeon house. If he fails to do so, then it will be considered that the defendant has not committed any tort. That is, if the plaintiff is successful in establishing that the wrongful act done to him falls under the category of a certain tort, then only he will be entitled to compensation. What is meant by trespass? Wrongly entering a person's house or land or interfering with his possession is called trespass or unauthorized entry. In a broad sense, it is also considered unauthorized interference in the right of ownership. In a narrow sense, unauthorized entry means unauthorized entry on land. Thus, the act of interfering with someone's possession can be called trespass. Entering someone's land against the wishes of its owner or causing any kind of obstruction is considered unauthorized entry. Any slight interference on someone's land without legal justification is considered the tort of trespass. If a piece of land is in the possession of a person, then taking out soil from it by another person without permission is also trespass. If a piece of land is in the possession of a person, then taking out soil from it by another person without permission is also trespass. Put on someone's land without legal justification is also trespass, even if no damage is caused. Trespass to land is actionable per se. That is, in these cases, the plaintiff does not need to prove damage. Trespass can be committed either by entering the land or by means of some object. For example, throwing stones on someone's land, putting nail in someone's wall, writing on someone's wall, leaving debris on the roof is trespass. In K.C. Alexander versus the State of Kerala, PIR 1973 SC 2498, members of a family were evicted from 160 acres of land occupied by them. They had illegally occupied that land and later enhanced it by building houses, etc., planting trees, etc., and digging wells, etc. Such occupation of the land was against the provisions of the Travancore Land Conservation Act 1910. The plaintiff's argument that he had entered the land in a good faith and with the intention of making additions to the land was not accepted, because if such an argument is accepted, it may lead to the disastrous consequences. Many people will deliberately try to take possession of another's land using similar arguments. Thus, trespass is a tort for which a suit for damages can be brought as it is self-actionable, and hence it is not necessary to prove the damage in such cases. What is the principle of contributory negligence? Contributory negligence means the negligence of the defendant as well as the plaintiff's own negligence due to which the adverse effect could not be prevented. Contributory negligence was defined in the case of Clayards versus Ethic 1848, 12 QB 439, as not being able to save oneself due to one's own negligence from the result arising from the negligence of another person, when the means and opportunity to do so are available, is called contributory negligence. Under contributory negligence, the plaintiff does not use his normal care, passion, diligence and intelligence so that he could avoid the consequences arising from the negligence of the defendant. If a damaged party contributes partially to the negligence by his action or behavior, then the law takes it into account. In the case of Union of India versus Hindustan Unilever Limited AIR 1975, Punjab and Haryana 259, the Punjab High Court held that contributory negligence is an expression which leads to the conclusion that the person who has suffered the injury is himself responsible for the tort of negligence and has himself contributed to the injury caused to him. In such a situation, the compensation should be decided accordingly. In this connection, the case of Gorbe Singh versus Dudwin Dola 1971 ACJ 137 is important. In this case, both the plaintiff and the defendant were driving their vehicles at very high speed. There was turn which was such that the drivers of the two vehicles could not see each other until they reached the crossing. The plaintiff who was driving his vehicles towards the turn had one hand out of the window of the vehicle. In the collision of the two vehicles, his elbow was severely injured. The court held both the parties liable and divided the amount of damage equally. What do you mean by wish measure? Sir Frederick Pollock has defined wish measure as act of God is an operation of natural forces such so unexpected that no human foresight or skill could reasonably or expected to anticipate it. Thus, an act of God is an event which is completely based on natural variation and which cannot be anticipated or predicted in advance, like lightning, floods, earthquake, etc. It is considered a defense to tort. Act of God immunity is available only if the following elements are present. One is the incident must have occurred due to natural forces. Two is the event is unusual and cannot be predicted. Therefore, those actions whose source is natural forces and which are not related to human agency can be called divine acts. In the case of Saraswati Tarabhai versus Grid Corporation of Odisha and others, AIR 2000 Odisha, where an electric pole fell on the road and a person died due to contact with the electric wire. The argument that if there was no storm, the pole would not have fallen was not accepted. The authorities were required to install such poles in such a way that they do not fall with the electric current. Hence the defense of act of God was not accepted in this case. Let us explain the no fault liability under Motor Vehicle Act 1988. Section 140 of the Motor Vehicle Act 1988 assures the principle of no fault liability. The section provides that where an accident arising out of the use of a motor vehicle or motor vehicles results in the death or permanent disablement of any person, the owner of the vehicle or owners of the vehicles, as the case may be, shall be jointly and severally liable to pay compensation in respect of such death or disablement in accordance with the provisions of this section. The amount of compensation which shall be payable under subsection 1 in respect of the death of a person shall be fixed sum of 50,000 rupees, and the amount of compensation payable under that subsection in respect of the permanent disablement of a person shall be fixed sum of 25,000 rupees. In a claim for compensation under subsection 1, the claimant shall not be required to plead or take the defense that the death or permanent disablement in respect of which compensation is claimed was caused by any wrongful act, neglect, or default of the owner or owners of the vehicle or vehicles concerned or of any other person. A claim for compensation under subsection 1 shall not fail due to any wrongful act, neglect, or default of the person in respect of whose death or permanent disablement, as the case may be, the claim is made and the amount of compensation in respect of such death or permanent disablement shall not be reduced on the basis of the share of such person in the responsibility for such death or permanent disablement. Notwithstanding anything contained in subsection 2 in respect of death or bodily injury to any person for which the owner of a vehicle is liable to pay compensation as relief, he shall also be liable to pay compensation under any law for the time being in force, but the amount of compensation payable under any other law shall be reduced by the amount of compensation payable under this section or section 163A. Thus, this section has been enacted to provide relief in case of death or permanent disability of the victim or his legal heir in case of an accident involving a motor vehicle. Let us explain the test created in Donald versus Stevenson 1932 to establish a duty of care. The case is related to negligence. In this case, the liquor company sold an opaque bottle of beer to a retailer. The retailer sold the bottle to a man and his girlfriend who started drinking it in the retailer's cafe. As they were pouring the beer into the cup, the rotten snail fell into the woman's cup. The woman became ill and filed a suit against the manufacturing company. The House of Lords held the manufacturing company liable for compensation and held that the company had a duty to take care of the consumer even though there was no contract between the company and the consumer. Thus negligence was established as a fault in this case. The defendant, a returning officer, refused to register the vote of the plaintiff who was a qualified voter. So the candidate from whom was a qualified voter, though the candidate from whom he wanted to vote wins, the plaintiff choose the defendant for compensation decide. In its answer, we can say the present case is related to infringement of legal right, infringement of legal right, without damage, injuria, sine damnum. Damnum. In such a situation, the plaintiff is entitled to receive compensation even though he has not actually suffered any damage. A schoolmaster, Mr. Francis, was removed from Royal Grammar School unlawfully. Immediately Mr. Francis opened a rival school opposite to Royal Grammar School. All the students from Royal Grammar School joined a new school. Consequently, Royal Grammar, the school was closed down and suffered huge losses. Now they want to take action against Mr. Francis, advised the Royal Grammar School authorities. In its answer, we can say this case is related to damage without legal damage. Damnum sine injuria, according to which it's if a person had suffered a loss but no legal right had been violated, then he cannot claim compensation for such loss. A and B are neighbors. A constructed a well in his land. Due to the same, B's well dried up. B wants to file a suit against A. Advise him. B cannot get any damage because no liability arises for damage caused by objects naturally occurring on land. The defendant told the plaintiff as a practical joke that her husband had met with an accident and was seriously injured and lying in the hospital. On hearing this, the plaintiff suffered a nervous shock and became ill. Can she claim damages? Yes. The plaintiff can claim compensation from the defendant in the case of Wilkinson versus Downston 1925 1 KB. It was held that the defendant is liable to pay compensation for such a trauma. The defendant sent nitric acid to the courier without any warning. The courier servant was injured by its escape while handling it. Is the defendant liable? Decide. In the present case, the defendant is liable to pay compensation because he sent the nitric acid for transportation without giving any warning, despite knowing that it was to be transported, and the plaintiff is liable for negligence and the defendant is liable to compensate the plaintiff for the loss caused by the leakage of nitric acid. X wrongfully obstructed a road by putting a pole across it while riding rashly on the motorcycle in the dust, was overthrown by the pole and injured. The pole was visible at a distance of 100 meters. Is X liable to Y for damage? This case is similar to Butterfield versus Forrester, 1809. 11 is to 60, according to which the plaintiff is not entitled to get damages because he could have prevented the accident by ordinary care. But later in the case of Davis versus Mann, 1842, 10M or W 546, the doctrine of last chance was propounded, according to which the plaintiff is entitled to damage because the defendant had the last opportunity to avoid the accident by exercising reasonable care and patience. The plaintiff was standing on the highway in a road adjoining a cricket ground when she was struck by a ball which had been hit out of the ground. Such an event was foreseeable, and indeed balls had to the defendant's knowledge occasionally being hit out of the ground before. Whether the plaintiff can recover damage from the cricket club. In the present problem, the plaintiff can recover damages from the cricket club because such accident was foreseeable and was in the knowledge of the cricket club. The sad accident was the result of the negligence of the cricket club. In the case of Counsellor versus St. Augustine, 1922, a golf club was held responsible as a result of a similar accident. He left his donkey trying its front legs. The donkey was run over by a car, negligently driven by B, and the donkey was killed. A brings an action against B to recover damages for the death of his donkey. The present case deals with the doctrine of contributory negligence and last chance. Contributory negligence is considered a defense to tort. In this case, the defendant is liable. So the donkey was there unreasonably. It was the duty of the defendant to go on the road at such a speed as to avoid the accident. The plaintiff is liable for negligence because the plaintiff had sufficient opportunity to avoid the occurrence of the damage, to avoid the occurrence of the danger by the exercise of responsible care and patience. Davis versus Mann, 1842, 10 M and W 546. A manufacturer of ice cream sold a substandard ice cream to the retailer, who is come sold it to a customer. The friend of customer become ill after consuming it. Discuss the choice liability. The present case involves negligence, which is a mental element of tort and is a definite tort. In this case, though the ice cream manufacturer has no contractual duty to the buyer, but he has a legal duty to the buyer to take care to maintain the quality of the ice cream and is liable for breach of this duty. Hence, in this case, the retailer has no liability, but the ice cream manufacturer is liable to the buyer for negligence. Dunop versus Stevenson, 1932, AC 562. He parked his car on a street with his dog inside. As B was walking past the car, the dog had been jumping inside and smashed the glass panel, and as a result a splinter hit BEYE and caused injury. Can P claim damages from M? This case is related to unavoidable accident. This is a defense to fraud. Inevitable accident is an event which a person of ordinary prudence could not have prevented even after taking all necessary precautions or care under the circumstances. In this case, the defendant is not liable to the plaintiff because leaving the dog in the car is not a dangerous act, and neither can any accident be expected from it. Padan versus Harcourt, Livingston, 1932, 146 LT, 391, giving the judgment in this case. Lord Dundin said that the people should be cautious about reasonable possibilities, but they are not bound by imaginary possibilities. Now, let us change the paper or the topic or title, you can say. Constitutional Law 1. Constitutional Law 1. Write a short note on the nature of the Indian Constitution. Constitutional scholars have divided the Constitution into two categories. One is Federal Constitution, two is Unitary Constitution. What is Federal Constitution? In this there is division of powers between the center and the states. This division is done in such a way that everyone is completely independent in their own field, and at the same time they are cooperative with each other and not subordinate to each other. Following are the essential elements of the Federal Constitution. One is written Constitution, two is supremacy of the Constitution, three is immutability of the Constitution, four is division of powers, and five is authority of the judiciary. What is Unitary Constitution? In this, all the powers are vested in a single government, which is usually the central government. The provinces have to remain under the central government. The main characteristics of a unitary constitution are as follows: creation of new states and power to change the areas, boundaries or names of existing states, who is power of parliament to make laws on subjects in the state list, is appointment of governor and for his emergency provisions. The aim of the makers of the Indian Constitution was to establish a strong and powerful center which would be capable of stopping external attacks on the country at any time and would be fully capable of suppressing internal destructive elements. To achieve this goal, the central government has been given more powers than the state governments. The Indian federal system is a changeable system, and as per requirement, it can take either federal or unitary form. Generally, its form remains federal, but in times of crisis from the point of view of national unity and security, such provisions have been included which convert it into a unitary structure. In the case of S.R. Bomal versus Union of India 1994, the Supreme Court held by majority that the Indian Constitution is a federal constitution and federalism is the basic structure of the Constitution. Justice Sri Sawat and Sri Kuldeep Singh have said that federalism prevails in the Indian Constitution and it has not ended in any way. Despite this fact, there are provisions in the Constitution under which the center has been given overriding power over the states. Yet our Constitution is federal. This means that the state is sovereign within its perimeter of territory. In conclusions, it can be said in brief that the Constitution of India is neither purely federal nor purely unitary, but it is a combination of both. That is, it is a semi-federal. This is a unique constitution of its kind. It recognizes the principle that national interest is permanent rather than the federal principle of professor. Virar also calls the Indian Constitution a semi-federal constitution, whereas Professor Jennings has called the Indian Constitution a federation which has a strong tendency of centralization. Let us state the main characteristics of the Constitution of India. One is world's largest constitution. Two is written constitution. Is incorporation of constitutions of different countries in the Indian Constitution. Four is preamble of the Constitution. Its fifth feature is dominant. Six is democratic. Seven is socialist system. Eight is parliamentary government. And its ninth feature is fundamental rights. 10 is directive principles of state policy. 11 is coordination of stiffness and flexibility. 12 is powerful center. 13 is independent judiciary. 14 is adult franchising. 15 is fundamental duties. 16 is establishment of secular state. And 17 is single citizenship. Let us state the essential elements of the federal constitution. Following are the essential elements of a federal constitution. One is distribution of powers. Division of powers between the center and the states is an essential element of the federal constitution. This division is done by the constitution itself. Every government is sovereign in its own territory and cannot encroach on the rights and powers of others. Thus, in federalism, the powers of the state are decentralized among many cooperative institutions. The source of all organs of government is the Constitution, which controls the exercise of their powers. What is supremacy of the Constitution? The Constitution is the source of all organs of the government, executive, legislature and judiciary. All provisions related to their form, organization and powers are contained in the Constitution itself. The Constitution sets the limits of their jurisdiction within which they function. All institutions work under the control of the Constitution. In a federal system, the Constitution is considered to be the supreme law of the country. According to Professor Stewart, the primacy of the Constitution is very important for the federal government and for its smooth functioning. It is also necessary for the Constitution to be written. The source of legislative power of the central and provincial legislature is the Constitution itself and is made by them. Laws are subject to the Constitution. If they go against the provisions of the Constitution, the court can declare them illegal. Similarly, they have to use all their rights and powers granted by the Constitution within the limits set by the Constitution. What is written Constitution? A federal Constitution is essentially a written Constitution. The establishment of the Union State is established by a complex contract in which the units join the Union only on certain conditions. It is necessary for these conditions to be written. Otherwise, it would be impossible. To keep the supremacy of the Constitution intact. Basing such a system on compromise and tradition will definitely create doubts and differences. Due to the written Constitution, both the central and provincial governments are clearly aware of their respective rights and they work with trust in each other. What is variability of the Constitution? The written Constitution is naturally inflexible. It is also necessary for the supreme law of the country to be inflexible. The flexibility and inflexibility of the Constitution depends on the process of its amendment. The process of amendment in the Constitution is difficult. It is called an inflexible Constitution, and in which amendments can be made easily. It is called a flexible Constitution. The Constitution of any country is a permanent document. It is said to be the supreme law of the country. To maintain the supremacy of the Constitution, the process of amendment needs to be difficult. This does not mean that the Constitution should be immutable, but only those changes can be made in the Constitution which are necessary according to the time and circumstances. What is authority of courts? In the federal Constitution, there is a division of powers between the central and provincial governments. This division is done by a written Constitution. Hence, it is necessary that this division of powers be maintained so that the central and state governments should not encroach on each other's jurisdiction. Since the division of government powers is done through a written document, it is possible that different governments can interpret the provisions of the Constitution in their own favor in such a situation. To interpret them correctly, an institution is required which is independent and impartial. This function has been assigned to the judiciary in the federal constitution. Only the judiciary has the authority to give the final decision regarding the interpretation of the provisions of the constitution. This institution is not subordinate to any government. It performs its function as a completely independent and impartial institution as a third part of the government in a federal system. The great task of protecting the supremacy of the Constitution rests with the judiciary. The interpretation of the Constitution made by the judiciary is binding on all authorities. Let us take a break, please. Law of contract. Law of contract 1. Law of contract. General principles of contract and Specific Relief Act 1963. Let us define proposal. When a person communicates to another his consent to do or refrain from doing anything with a view to obtaining the consent of that other person towards such action or inclination, when he is said to make a proposal. In simple words, when one person expresses his desire to another person to do or not to do any work with the purpose of obtaining that person consent regarding doing or not doing that work, then it is said that the first person has proposed the other person. Section 2A. Let us define acceptance. When the person to whom the proposal is made expresses his assent to it, then the proposal is said to be accepted. Thus the person before whom the proposal is made expresses his consent to it, then it is said that the proposal has been accepted. Promise. In the same section, the word promise had also been defined. A proposal, when accepted, becomes a promise. Thus the proposal accepted in this way is called a promise. Therefore, when the proposal is accepted, it is known as a promise. Section 2b. Just define promiser and promisee. Promiser, the person making the proposal, is called promiser. Promisee, the person accepting the proposal, is called a promisee. What is renewal of contract? Renewal is not defined in the Indian Contract Act. What we mean by novation is, what we mean by novation is, when a new contract is substituted for the first contract between the parties or between different parties, it is called novation of the contract. The definition of novation in the words of the House of Lords is as follows. When, while a contract is in existence, a new contract is made for it, either between the same parties or between different parties, and the result of which is the mutual discharge of the old contract. In this way, no novation, a new contract is substituted in place of one contract, as a result of which the parties to the old contract are released from their obligations. This renewal takes place with the mutual consent of the parties. Section 62 of the Indian Contract Act provides that if the parties to the contract agree to substitute a new contract for the contract or to rescind it, it is not necessary to perform the original contract. The effect of renewal on the contract is that it is no longer necessary to follow the original contract. The reason for this is that a new contract has been substituted in place of the old contract. What is consideration? When, at the will of the promiser, the promisee, or any other person has done or refrained from doing, or does or refrains from doing, or promises to do, or refrain from doing, then such act or the practice or promise is called the reward for the promise. In this sense, when at the will of the promisers, the promisee or any other person has done or abstained from doing some work, or does some work or abstain, or does some work or abstain from doing it, or promises to do or abstain from some work, then such work or abstinence from it or promise is called the reward of that promise. Section 2b. What is illegal consideration? By analyzing Section 23 of the Indian Contract Act, it becomes clear that if the consideration for a promise in an agreement is illegal, then the effect of that contract becomes void. Following are some of the types of rewards and objectives which are prohibited under Section 23. What are prohibited by law? What is prohibited by law? A contract which is contrary to the law or against its policy will be considered illegal. It is not necessary that the object of the contract be clearly declared to be against the law. Even if the consideration is of such a nature that it adversely affects the objective of the law, it will still be considered prohibited by the law. The contract will be invalid in both the circumstances. When the promise made in the contract is such which is prohibited by law, when the promise is made for a consideration which is prohibited by law. For example, A makes an agreement with B that if he kills C, he will give rupees 1000. The agreement is void because here the consideration given by B for killing C is rupees 1000 and this action of B is against the law. Hence, this agreement is void. The agreement is such that it would frustrate the provisions of the law. The word law used in this section includes the following acts. One is legislative acts, two is acts of Hindu and Muslim law, three is such acts which have the power of law. Let us define one, nullifying the provisions of the legislative act. Legislative acts mean such acts which have been passed by the central legislature or the state legislature and which are enforced at that time. If the consideration for the promise made in the contract is such that it is contrary to these acts, then the contract will be void. An agreement made between the adoptive father and the natural father of his son to the effect that the natural father of the adopted child will pay an allowance of rupees 2000 per annum as a result of adoption is void because it is against the policy of Hindu law. Such agreements which frustrate the rules of law for the time being enforced in India. Such agreements which frustrate the rules of law for the time being enforced in India will be void. What is fraudulent? The object or consideration of any agreement is vitiated by fraud. For example, A, the agent of a landowner, for money without the knowledge of his owner, agrees to lease a piece of land belonging to his owner to B. This agreement is void because it involves concealment and fraud by A from his owner. What is considering causing injury to body or property? An agreement made to cause injury to the body or property of any person is void. For example, A asks the editor of a newspaper to publish a defamatory article against B and promises to pay rupees 1000 in return. The agreement is void because its object is to cause damage to B. What is immoral? An agreement whose object or consideration is immoral will be void and cannot be enforced. This rule is based on the general principle of this sutra, which means that the court cannot assist a person whose cause of action is based on any immoral act. For example, A agrees to give his daughter on rent to B to keep her as a concubine. This agreement is void. Agreements having a consideration or purpose contrary to public policy. Such agreements whose consideration or purpose is contrary to public policy are illegal. Although the definition of public policy is not given in this Act, still the following agreements are such which can be considered against public policy. One is such agreements which cause injury or to other states. Two is agreements damaging public services. Three is agreements that obstruct the course of justice. Four is agreements abusing the legal process. Five is agreements contrary to good conduct. And sixth is agreements affecting freedom of trade. What is insufficiency of consideration? Section 25(2) of the Indian Contract Act deals with insufficiency of consideration according to this. An agreement to which the consent of the promisor has been freely given is not void merely by reason of the consideration being inadequate, but the insufficiency may be taken into account by the court in framing the question whether the consent of the promisor was freely given. For example, A agrees to sell a horse worth rupees 1,000 for rupees, notwithstanding the fact that the consideration is inadequate. This agreement is contract. Thus we see that an agreement does not become void because of insufficiency of consideration. This is a matter for the parties. The principle of English law is that it should be realistic. Under the interpretation of section 25, it is not necessary that the consideration be adequate, but when inadequacy of consideration is found in circumstances of indebtedness and ignorance, these facts are considered to be such from which it can be inferred that undue influence has been exercised. Inadequacy of consideration at best provides evidence that the consent of the promisor was not freely obtained and nothing more. Let us distinguish between void agreement and unlawful agreement. The term void agreement has been defined in section 2Z of the Act, whereas the term unlawful agreement has been used in section 23 and 24. The scope of void agreement is narrow, whereas the scope of illegal agreement is wide. A void agreement is completely void, whereas an illegal agreement can be partly illegal and partly legal. Void agreements are generally only those agreements declared void by the Contract Act, whereas illegal agreements can also be based on illegality, under other laws or on the morality and public policy prevalent in the society. It is notwithstanding here that the term illegal agreement also includes illegal agreements. Similarly, it should also be kept in mind that all illegal agreements are void, but not all void agreements are illegal. Section 23 of the Contract Act says that every unlawful agreement is void, but it is not necessary that an agreement be declared void in various sections of the Contract Act is an unlawful or illegal agreement. This can be made clear from the voidness of the wagering agreement mentioned in section 30. Wagering agreements are void but not illegal. In in criminal law. In criminal law, the parties can be punished for making an illegal agreement, whereas for making a void agreement, the parties cannot be punished. Similarly, void agreement have no effect on other subsidiary agreement, whereas an invalid agreement has an effect on its subsidiary agreements and they also become void. Under the Dowry Prohibition Act 1961, the transaction of dowry is called an illegal agreement, whereas it is not declared in the Contract Act as a void agreement. Yes, under section 23, this agreement is void as it is illegal. Explain. Time is the essence of contract. Time is of the essence of the contract. What we mean by this statement is that when two parties make an agreement, time for performing duties under a contract can be made a condition of the contract and this time can be the essence of the contract. According to section 55 of the Indian Contract Act, whereas a party to a contract promises to do anything at or before the time specified or to do anything at or before the time specified, and if he fails to do so at or before the time specified, the contract or so much of it has not been performed becomes void at the corruption of the promises. If the parties intended that time should be of the essence of the contract, it is clear from the above provisions that whether time is of the essence of contract in a case or not depend on the intention of the parties. In this regard, the case of Bhadarchand versus Betas 1915 is important. The facts of this case are such that the plaintiff had undertaken to deliver an elephant to the defendant on October 1, 1910 by capturing wild elephants. Later on request, the defendant granted permission to deliver the elephant by October 5. He was unable to deliver the elephant even on 6 October. Later he offered to deliver the elephant on October 11, 1910, but the defendant refused to accept it. The court in its decision held that time was the essence of the contract in this case. Therefore, the defendant was entitled to refuse to accept him on 12th October. Judge Fazal Ali has said in his decision in the case of Kari Singh versus Antar Singh that the general rule is that where the time of the contract is fixed, then it should be performed within the stipulated time. Otherwise, it should be performed within a reasonable time. In commercial contracts, where a specific time has once been fixed, the presumption is that the time is of the essence of the contract, unless the contrary intention appears from the words of the contract or from other circumstances. What is reciprocal promises? These promises, which are a consideration or a part of the consideration for another, are called reciprocal of reciprocal promises. Thus, such promises which are considerations or partial consideration for each other are called reciprocal promises. Section 2F. Next, we will discuss tomorrow, explain the permanent and temporary injunction. Let us take a break, please. Let us describe the various sources of Hindu law. There are following sources of Hindu law which can be divided mainly into two headings. One is ancient sources, two is modern sources. In ancient sources, this includes the following. One is Shruti. These are those sentences which were spoken by God and heard by the sagas, Vedas and Vedanta have been kept in it. What is Samriti? These are those sentences which the sagas heard and remembered from their ancestors and reminded them to their disciples. It contains some verses which are called Dharam Shastra. These commentaries and essays, commentaries on Smritis have been made by them. For its customs, these should be ancient and continuous and should have the force of law. What are modern sources? It includes one is justice equity, where there is no rule or law of any previous decision available to solve a problem. Then the judge can take the decision as per his discretion. But the condition is that this discretion should be judicial. Legislation, its importance started from the British rule period. The laws and rules made by the legislature and the rules, bylaws, etc. made by the authorities come under this. These judicial decisions. Decisions given by Supreme Court, High Court and Privy Council on Hindu law fall in this category. These decisions have binding effects on everyone. Let us differentiate between Shivat and Mahant. There are following differences between Shivat, Shivayat or Mahant. The manager of a temple is called a priest or Shivat, Shivayat, while the manager of a monastery is called a Mahant. The position of Shivayat is relation to the temple property is like that of a trustee. Mahant does not maintain accounts as a trustee. By the nature of the work, Shivayat is the administrator of the temple property. The work of Mahant is governed by tradition. In the temple, the idol of God is in the position of the president and Shivayat is in the position of his minister. On the other hand, in the monastery, the Mahant himself is the president. There may be more than one Shivayat in a temple, but there is only one Mahant in a monastery. The owner does not have the status of service on the money received from gift etc. and she cannot use the property as per his wish. Whereas the Mahant gives the gift, he himself is the owner of the money, received all the powers to use that money are vested to him. Termination of service depends on those conditions which have been credited by the trustee. In his absence, the service goes by inheritance, whereas the devolution of the post of Mahant depends on the practice of the monastery. The Mahant himself can nominate its successor, or he can be elected by all the members of the mutt. Next topic we will discuss. Let us define labor and industrial laws 1. What do you understand by the term labor welfare? Labor welfare relates to taking care of the well-being of workers by employers, trade unions, governmental and non-governmental institutions and agencies. Welfare includes anything that is done for the comfort and improvement of the employee and is provided over and above the wages. Welfare helps in keeping the morale and motivation of the employees high so as to retain the employees for longer duration. Employee welfare includes monitoring of working conditions, creation of industrial harmony through infrastructure for health, industrial relations and insurance against disease, accident and unemployment for the workers and their families. Oxford Dictionary, labor welfare is efforts to make life worth living for workmen. The need for providing such services and facilities arise from the social responsibility of industries, a desire for upholding democratic values, and a concern for employees. Welfare includes anything that is done for the comfort and improvement of employees and is provided over and above the wages. According to ILO, labor welfare can be defined as a term which is understood to include such services, facilities and amenities as may be established in or in the vicinity or undertakings to enable the person employed in them to perform their work in healthy, congenial surroundings and to provide them with amenities conducive to good health and high morale. Next, let us discuss the constitutional provisions, Article 39 regarding labor welfare. Article 39 of the Indian Constitution specially deals with labor welfare. Article 39 contains 6 clauses that all the citizens, irrespective of their sex, whether man or woman, shall equally have the right to adequate means of livelihood. Article 39A of the Indian Constitution, that the resources and the ownership of those resources and materials shall be distributed in such a way that it fulfills the common goal. Article 39B of the Indian Constitution, that the economic system shall be executed in such a way that the concentration of wealth and means of production shall not result in a common detriment. Article 39C of the Indian Constitution, that equal pay for equal work shall be promoted. Article 39D of the Indian Constitution, that the health and strength of workers, irrespective of whether men, women or children, shall not be abused or manipulated. Further, economic necessity or condition shall not be the reason for entering such avocation that is unsuitable for specific age or strength. Article 39E of the Indian Constitution, that appropriate opportunities shall be given to the children that would help them in building in a healthy manner and in the condition of freedom and dignity. Further, childhood and youth shall be protected from any kind of exploitation and against moral and material amendment. Article 39F of the Indian Constitution. Article 39F of the Indian Constitution 1950 was substituted through the 42nd Constitutional Amendment Act 1976 to expand the scope of the said article. Previously, Article 39F stated that childhood and youth are protected or guided against exploitation or manipulation and against moral and material abandonment. Now let us discuss next topic related to General English. Is related to General English, legal language, legal writing. The paper is related to legal language and legal writing. How does it start? Functional grammar and English language skills. We are on the way to your home. She always brushes her teeth at night. I was born in May 2000. She left home for 5 months for some reason. My parents want me to be at home by 8 p.m. I have been awaiting for you for the last 2 hours. She loves to swim early in the morning time. The owner shifts the dues to the next week. The work has finished before the deadline. We can dance together till he comes. World War II had ended in 1945. These girls were roasting during the lectures. These girls were worshipping during the lectures. The teacher asked him to call his parents on Monday. I will see you in court. I have completed my graduation from 2010 to 2015. They will be there for your help until Friday. Jimmy has been hiding here since last week. Ranbir was feeling nervous before the interview. We felt confident and happy after the interview. Students Saturday to next Sunday to such kind of traditional words are very important from the exam point of view, from the preparation of grammatical topics. Moral topics we will discuss later on. Thank you. Nice to see all of you. Nice to talk to you. Nice to interact with you. All my brothers and sisters, ladies and gentlemen, students, scholars, teachers, trainers, professors, professionals, respected doctors, directors, honorable ministers, ministers, and honorable advocates, advertisers, administrators, the most honorable President Professor Modi ji, all my listeners and learners, I heartily, cordially thank all of you. I thank all visitors, digitally. Thank